And we are live. Welcome to Crypto Law TV. I'm John Deaton, the founder and your host. And today is a very big day, a very special show for everybody. Today is the 5th anniversary of the most, in my opinion, arguably the most infamous speech ever given by a senior director or official from the SEC, Bill Hinman. Former director of corporation finance, gave his infamous June 14th, 2018 speech that declared Ethereum, although it started as a security, is no longer a security. Very big market moving news. And the emails that were just unsealed, that were fought for 2.5 years, 7 court orders, emails that were going to shock us or that were well worth it. All of those things got released. We're here to talk about it. And my first thoughts are this. The emails have been described by some as a nothing burger. They've been described as some as pure proof of corruption and all of this. The reality is it depends on your perspective, right? If you were anti-Ripple, anti-XRP, it's a nothing burger. If in fact you are an XRP holder, it's validation of everything that you knew was transpiring behind the scenes sort of got validated. I will believe it's validation. I do believe that because Crypto Law put a video library out together that kind of documented all these events. And we demonstrated what we believed was taking place behind the scenes. And in fact, these emails, these speech drafts absolutely prove that. A CoinDesk article just came out discussing XRP holders in the fight that we've been engaged in for years. I want to set the stage, though, for people to understand this speech. On December 13th, 2017, that's when Hinman met with Consensus and Joe Lubin and, the ETH founders. And he was represented, and Consensus was represented by Jay Clayton's firm, Sullivan and Cromwell. And they got these meetings, and those meetings continued for months and months leading up to the speech. In January, Jay Clayton gave a speech, and he went to Chris Dixon at A16Z, and they discussed what these market participants wanted. And Jay Clayton said, put together a memo and give it to Bill Hinman. And that memo, right? There was more meetings after that, but that memo was dated March 26, 2018 by Perkins Coie. That's the infamous memo there. This working group, which was of ETH investors primarily, put together a memo and gave it to Bill Hinman. 2 days later, they had a meeting about that memo and what they were asking. And that memo, basically, you see it as it appears in the speeches. May 3rd was the first time we see that there is a draft of the speech, okay? And that, look what it's titled, May 3rd. When does a security stop being a security? You're going to learn that this was all about the acceptance that ETH started as an ICO, a pure securities offering. In fact, later on in that same document, it says ETH clearly started off as a security. Pure ICO right there, clearly began as a securities offering. Because it's an ICO, there was no foundation, there was no network yet, no blockchain. They raised the money and they built it. So everyone agrees an ICO, a pure ICO, is a securities offering. And so then we see another rendition of the speech on May 24th, and that's when we see the first real speech. And guess what? Words that were used in that Perkins Coie memo appear verbatim. Words like, I have it written down, irrational exuberance, right? That's something odd. That was in the Perkins Coie memo. That shows up in the initial draft. Something that I believe in, the token itself is not a security. That's in the Perkins Coie memo. That ends up in the first draft and in the final draft. And so the bottom line is the ETH investors who met with Bill Hinman, their memo, it tracks his speech. And then finally on June 4th, remember that first title I just showed you, when does a security stop being a security? Bill Hinman called it something different. He called it the ether speech. Notice in the speech, he talks about Bitcoin and ETH, but he doesn't call it the Bitcoin and ETH speech. He calls it the ether speech. And what we learned from the emails finally was that Hinman was not following the law. His own people, Director of Trading Markets, Office of General Counsel, were saying, stick to Howey. Stick to Howey, stick to the law. You're bringing up new factors, sufficient decentralization, asymmetries, things of this nature that they're saying, hey, leave that stuff out. But Bill Hinman kept it. He included actual elements and points that the Office of General Counsel said are irrelevant, but he wanted it. And those things, of course, were something like if a group owns a substantial amount of the tokens, and they're motivated to increase the value, Bill Hinman said that's important. The Office of General Counsel said not so much. Now, why would Brad Garlinghouse say that's shocking? Because you can see the roadmap where Ripple's being targeted and ETH is getting it passed. And so that's my initial thoughts. What I want to do is I have an all-star panel for you. And the first person I want to bring out is Carl. Carl is an attorney, counsel for Roslyn Layton. There he is. And he's someone who fought for these documents. He actually played an important role, him and Roslyn Layton, to get these documents, putting added pressure on the judge that says, you know, here's a motion. These need to be heard to the public. Carl, welcome. Appreciate you being here.
John, thanks so much for having me on. I really appreciate it.
So my first question to you is, you know, I know Roslyn has shared her own analysis in an article, and there it is in DC Journal. And, you know, it was a great article as usual from her, but I want to get your thoughts. Why did you file the motion that you did?
Well, I mean, I wanted to do it because Roslyn asked me to help her. And I think collectively we realized that the documents, the Hinman documents, were not only really important to Ripple, and they've got obvious importance to its fair notice defense, but they've also got a lot of importance to the public. And, you know, I kind of took Roslyn's lead on this because she's more of an expert in the regulatory area than me. But, you know, it's really important for us to all understand how the SEC is making decisions about how to regulate cryptocurrencies. It's not only important for Ripple, it's also important as, you know, as the agency goes into this new era where we have a new currency, we have new issues to be dealing with. So there's a lot of scrutiny. And of course, you know, it's important to all of the XRP holders and, you know, to your clients and everyone else to see what's happening inside the SEC. So we thought it was going to be important to expose those ideas about developing the Hinman speech to sunlight, to see how much thought really went into this, who might have been pushing back on what Hinman was saying. Did the agency and, you know, officials think that they were giving enough guidance, and was the agency functioning properly? I think these are really important questions for everyone. We wanted to bring them out.
Okay, now let me ask you what, because I think what you did was very important, and I would encourage others that have an interest, such as Roslyn, to employ the same tactics. You know, I filed a motion to intervene on behalf of individual XRP holders as defendants. You know, a very odd, you know, bizarre, a lot of people call it motion because we were saying name us as defendants too, because you've effectively sued us. What was your legal argument to even obtain these? Because I want others to be motivated or inspired by such moves.
So our basic right to come into the case stems from Roslyn's status as a journalist and a scholar in this area. And it's because, and this is an argument that's really specific to sealing motions and whether or not information should be revealed to the public. So it's different than trying to make yourself a party to the case or try and, you know, intervene explicitly on one side. What you're really saying is, in a motion like we filed, we just think that these documents that somebody wants to keep secret ought to be made public. And it's because the First Amendment has the right, the First Amendment gives the public the right to see presumptively what is in court documents. And, you know, in this case, Ripple made the Hinman documents court documents by appending them to its summary judgment motion in support of its fair notice defense. So we're saying that everybody should be able to see that, not just Ripple. And the SEC opposed that motion, saying, we have a lot.
Let me take a guess. We don't want you to see how the sausage is made. If you unseal this, it's going to chill people in the future from having independent, open dialogue and all those arguments.
Well, I think you don't want to see how the sausage gets made is probably the subtext. The text of what they were saying was, yes, we're doing agency deliberation here. This is really important. We don't want to chill the free exchange of ideas. There was some discussion early on that some of the people who were consulted were lawyers for the SEC, so they might have an interest in in attorney-client privilege and work product in the speech. A lot of that stuff fell by the wayside before we even got involved, but a lot of it fell away because at the end of the day, the SEC was kind of speaking out of both sides of its mouth on the whole issue of the Hinman documents. On the one hand, they were trying to minimize their importance, kind of don't look, there's nothing to see here. These are not the droids you're looking for because this is just a private speech by him and it doesn't reflect the policy views of the SEC. And that was probably the early tact that the SEC took on those documents. But then I think as there became more scrutiny from the public, from people like you and your amici, John, I think they started to worry a little bit more. And then they started to raise these issues about privilege and agency deliberation and the need for free exchange of ideas, et cetera, as a grounds to overcome the First Amendment right to have these documents made public.
All right, so I have to ask you, you've seen some of the emails, I imagine, you've looked at it. What's your take? You fought to get these, so I want to know what you think of them. So we sort of anticipated, what might be in these documents that we can't see. And, I thought maybe there might be, pushback inside the agency. Maybe somebody might be saying there's not enough guidance here. Maybe we shouldn't, maybe we shouldn't be adding a lot of factors onto the Howey test. These were things that we anticipated. And on that score, the documents turned out to be much more significant than I originally thought, because you have everything, you have all the ingredients that we thought might be there. You have pushback from inside the SEC. And I think most strikingly, you have pushback from SEC general counsel, the person, in charge of deciding who's going to get charged, saying, no. We don't think this is enough. We don't think this is right. And then you have Hinman going out into the public and saying these things anyways. It's essentially the agency deceiving the public, because you've got the SEC general counsel saying, I do not want to do this. I don't want to enforce on these terms. I don't want to go out there without enough guidance. I don't want to be adding a bunch of legal tests that don't really have support. It's going to create more problems than it's worth. And you have Hinman going out and doing it anyway. And that was really striking to me. I'm not saying that they're definitive. I think you're right. There's a lot of documents here, and people are going to look at them and largely see what they're expecting. But we were surprised at the degree of pushback that Hinman was getting inside the agency, specifically about lack of direction. And, the fact that this whole approach of making a speech and then going ahead and suing some guys wasn't likely going to work. I made a prediction that the documents would make even people who are not as close to the case as I am, who've been arguing about conflicts of interest and all that, would make a normal person be like, why go on a limb and give this speech? Do you find yourself in that category?
I'm not an expert on the SEC, but I keep watching the agency's moves in this space and keep wondering why. Why is the question that keeps popping up? I mean, they could propose a rulemaking. They could give some more official guidance, but instead it's almost like they're deliberately trying to hide the ball and then going out and seeking billions of dollars from issuers. And that's really a troublesome way to go about doing business. I mean, I hate to tie it back to this, but that's kind of what we had hoped to shine a light on in having these documents made public. And we're really glad that it worked, because it shows an agency in dysfunction over this particular area of regulatory enforcement.
Well, listen, I'm glad, and you just gave me a perfect segue for me to bring on a couple other guests. I know that I want to thank you for your time. Maybe if you're still around at the end, we'll bring you back and ask you some questions. And if you're not and you got to go, that's fine as well, Carl, because we do have someone who worked at the SEC who's been in there while the sausage was making it, and maybe he'll be able to give us some perspective. Okay. And so first I want to say thank you. And I'll talk to you soon. Okay, Carl?
I really appreciate it. Thanks you, John.
Thanks
John.
And give my best to Roslyn. And what I'm getting at is I have Marc Fagel as one of my guests, along with someone everyone knows in this community, Jeremy Hogan. And I told Marc before we came on air live, I said, when you go on a limb and disagree with me publicly, but you do it with such good civility and respect, you're rewarded by me asking you to come in, because I think it's important, Marc, that we get your perspective. And you've been someone who's taken the other side. And I want people to know that you have been an SEC enforcement lawyer, but you've also fought the SEC as a defense lawyer. And so welcome, Jeremy. Welcome. Thank you so much. Jeremy is someone who I know that if there's one person that maybe's read everything more than me, it would be Jeremy Hogan in this case. So I'm happy to get your perspective as well, Jeremy. So first, Marc, I do want to ask you, just were you listening to me and Carl?
Yes.
And so I just asked you, do you have any thoughts on like his conversation about, why the SEC would allow this speech to go out if there was pushback, if you have a thought on that?
Yeah, I try to stay away from ascribing motivations to people. As you said, having been on both sides, I could put on my SEC hat and say this is all good faith. It's an emerging legal issue, and people within the agency are struggling with devising a policy, and maybe some people wanting to put out what's essentially a think piece, and others taking the more traditional view that really that's dangerous to do that. I could put on my defense counsel hat and say, well, once it's out there and others within the agency are pointing to it, obviously that's going to create perceptions or misperceptions. So, I do try to see both sides of it. So I don't like to leap to, there's something unethical here, although obviously we can all agree that there are some conflict issues here and some really disappointing conduct here. But for the most part, I look at this as, okay, this is, how the sausage is made. But there's a reason for that. Anytime there is some emerging issue, there are different voices. The SEC is not monolithic. My background was enforcement, and there were a lot of cutting edge issues I worked on. I was there for 16 years at a pretty high level, and there were always issues that would be controversial. Other divisions would push back. I would be sometimes embarrassed if that were to get, see light, especially if we went into litigation, and that could be exploited. But that is a natural way of developing policy.
Okay, so there's probably been nothing, Jeremy. I want to turn to you and Marc. We're going to come back to some of the things I want to unpack about the agency and what it might be like to be in enforcement right now with all this public publicity on these emails. But Jeremy, I said that this is probably, other than summary judgment, these emails are probably the most anticipated issue in this case. Would you agree with that or disagree?
So far, absolutely. Other than the end of the case, yeah, absolutely.
And it's one of those things. Do you have any thoughts on the anticipation? That and the buildup for 2.5 years and 7 years. Do you have any thoughts on that? And then I just want your thoughts on the email, and then I'll go to Marc.
Sure. So obviously, the last 2 years. We've been waiting to see what's in these emails for 2 years now, right, John? So the anticipation and the buildup has been almost impossible for reality to meet expectations, right? There's no big bombshells that we're seeing in these emails. There's nothing that jumps out at you saying, "Ha, Ripple's going to win," or "Ha, the SEC is going to lose." There's nothing in these emails that screams that out. There's no. We were kind of thinking maybe there would be someone in the email that would have said, "Hey, what about XRP? It's just like Ether. Why aren't we including that in our analysis?" So we don't get anything like that in the emails. I think when I first read the emails, the first thing that jumped out to me was that I got this feeling that it's really bad for Hinman of all the people involved. it's obvious that he was pushing the Ether free pass, which had just been some conjecture on Twitter up to this point. And then we really see in these emails that right from the get-go, he even named, like, the title of his first email was, the Ether speech. And right from the get-go, he's saying Ether is not a security, and that was the point of him making the speech. And you got to think, well, why did he have to use Ether as an example? Why couldn't he just say once an asset reaches a certain level of decentralization, then it's no longer security? Why did he have to use Ether? And I think what I came away from reading the emails was, wow, there really was something going on here. And I haven't really talked about that too much in the past because I'm really focused on the case. But I think if I was, William Hinman, I'd be more concerned about these emails than maybe if I was the SEC.
Yeah, Marc, let me ask you first, what's your thoughts on the emails? And I do want you, after you give us your general thoughts, to give us an idea of what you think might be, these emails being public, is that embarrassing to people at the SEC? Or if it was you, would it be, or is this no big deal? If you could give that perspective as well, in addition to what your overall thoughts on the emails are.
Yeah, it's hard to quarrel with anything Jeremy said on the ethical aspect and certainly the optics. I don't want to ascribe motivations. I've never met Bill Hinman. I don't want to get behind that door there. But yeah, it does seem unusual, and I think people on the staff would chafe at that. I mean, just to give the example, I ran a regional office. I had over 100 people working for me. I had to tell them when they went to visit an advisor or broker or one of the registrants that we evaluated, they couldn't take a muffin. I mean, literally, you could take a Diet Coke, but you could not take a muffin that was offered to you. That was the sort of ethical strictures. I mean, the SEC, almost to a fault, is religious about that. So when you see something like this and the suggestions that you can draw from these emails, that would be frustrating. It's frustrating to me as an alum, and it's frustrating, I'm sure, to the staff to see that. At the same time, I do try to focus on the case itself. I think, in one box, you have what Jeremy is talking about in the optics of it, but you ultimately have the Ripple case. And I do think it's important to second what I think the two of you are saying, which is there's no real bombshell here on the merits of the case. And I think that's most important. There is nothing in here that tells you that there is a problem for the SEC's view of whether or not Ripple violated the law through an offering. There are some defense issues here, obviously. I think in terms of the scienter of the two individuals who were charged, it's more fodder to show if there is confusion with the SEC, how do you charge individuals with this higher level of intent that needs to be shown for an aiding and abetting charge. That was already a pretty weak case. I was surprised the SEC brought it. I can speculate about why they might have, but that was always a little weak, and this certainly doesn't help strengthen the SEC's case, to say the least. And then you've got this fair notice defense. I do think there's a bit of a misperception in the public. That is not a very strong defense generally. I don't know if there's ever been a successful fair notice defense against the SEC. It's much narrower than people, at least in the Twitter universe, seem to think. But to the extent that there is some receptivity by this court to that defense, there is some material that the defense can work with in the emails. That's there. But for the underlying merits, I don't see any game changers here.
Let me ask you, then I'm going to turn to Jeremy, because I have to ask you this. I don't get to talk to many SEC alums who've got the kind of experience you do. I got to tell you, we see the SEC and senior personnel, including Gary Gensler, refusing to talk about specific platforms, tokens. It was the way it was before the speech, and it's been the way it is ever since the speech. And when you say something as market moving as ETH is not a security, and give that kind of regulatory clarity, I gotta believe that would be normally the SEC ethics office would be involved. Wouldn't that be screened, or how does that work? I'm sure you gave speeches. Like, is there an automatically you submit it and it gets reviewed? Or because it's shocking to me, because I've taken the position that a first day paralegal would have been able to find the conflicts. His law firm had an IPO with Canon that did Bitcoin and ETH mining equipment that was being worked through. His law firm was a member of the enterprising theorem alliance. He had previous knowledge with these individuals. And so how does it work? Like it's just mind boggling to someone like me that, and I looked at the email distribution, and the one division missing, Mark, is the ethics office. So anything you can clarify?
Sure. So let's break that into two pieces. On the optics of it, and I agree with you. I think there's been a lot of pushback on Chair Gensler being so reluctant to address ETH in his congressional hearings and so forth. Whereas for me, that's the norm. He should not be speaking about any particular asset out there. So that's why the Hinman speech does stand out a little bit. That is not the SEC's norm to address a particular entity that the SEC may or may not be regulating. Maybe Bitcoin, there's an argument, there's something different about that, but that does stand out. In terms of ethical clearance, I gave speeches all the time. Mine were generally different. I have an enforcement background. I would generally be invited to panels and programs to talk about what's the SEC Division of Enforcement doing. Here are all the insider trading cases we brought in the last year. Here are some trends. Here are some of the things we're seeing in the industry. I wasn't really devising policy. So this is a little outside my background. And partly because of that, it was not my understanding there would generally be a separate ethics office review of the presentations because it didn't typically raise ethical issues. What I was doing, the general counsel's office would review our public statements. My assumption was they were there as an issue spotter for potential ethics issues, that there's not some grand chasm between the general counsel's office and the ethics office. It may even be that the ethics office reports into the general counsel. So I don't see that as a huge divide. It doesn't strike me as strange generally that there is not a separate ethics office review. There are some differences here, obviously, because of the well-publicized issues that Bill Hinman had in terms of his pre-existing relationship with his law firm. That's a little bit different. That was not my experience. When I gave speeches, when the other officials that I was friends with would give speeches, we didn't have conflicts of that nature. So it wouldn't be, we need to run this by ethics. That was not a present issue for us.
All right. Jeremy, and we're going to come back, Mark, and talk about the Office of General Counsel. I want to follow up on that. But Jeremy, right now, to the XRP holder that follows you, that's followed me, you're probably the best voice for them as far as they rely on your interpretation. They're sitting there saying, okay, John, we're like, 27 minutes into your show. How does these emails impact me as an XRP holder who is waiting for this result? What impact, if any, does this have on the case?
Well, I think the first thing is that as far as the Section 5 violation, I don't think these emails are going to come into play too much. These emails would come into play at trial, which would be not till next year at the earliest, on a fair notice defense trial with a jury. Now, I know Mark's position on this because I've been following him on Twitter. And by the way, Mark, if you don't feel it, I think everyone really appreciates that you're out there on Twitter because you're espousing the opposite view. You attract the haters. And I just want you to know that everyone who's not a hater,
my wife, because she's dubious.
Yeah.
Thanks, Jeremy.
Yes. I'm trying to say we appreciate you for sticking your neck out there like that. And it's a tough thing to do because I've been on the receiving end of some of the hate. I'm sure you have too, John. And it's not easy, but we really appreciate your input because at the end of the day, what we're trying to do is just kind of inform people that hold XRP that don't have legal background, what's going on, what to expect. And sometimes we get it wrong, sometimes we get it right, but we really appreciate your input for sure. I think, and I disagree a little bit with you, Mark, as far as, how these emails could be used, because to me, I see a lot of fodder in here at trial if it does go to trial maybe next year, maybe early 2025, because I think what you're seeing is evidence that's going to be used as to what when you have the regulators themselves having these discussions. I know that's how the SEC operates, but when you can get that information in front of a jury and you can say, look, Ripple's being charged with, breaking the law. They're horrible people. Look at what they did. And then you see that the SEC, the regulators themselves, were also having some confusion, also arguing over what these things mean. I guess for me, when I go to trial, and I'm in the middle of one right now, but I see myself as a lawyer. My job is to make my client look good and to make the other guy look bad. And I think these emails could be used not so much to make the other guy look bad, but certainly to paint the picture of an SEC that was as confused as Ripple was. And I think if you can get that in front of a jury, not so much a judge maybe, but in front of a jury, I think you could definitely use these emails to paint a fair notice defense. And I know that it hasn't been a particularly strong defense in the past, but this isn't just a defendant who's coming in saying, well, I didn't know what the law was, therefore don't find me guilty. The SEC has done a lot of affirmative things with the FinCEN settlement and all of the guidance that they gave, and some of contradictory guidance, because now they've backed off, I think, this William Hinman speech to an extent. But I think with all of the affirmative things that the SEC has done, I think if you can get this all in front of a jury, I think you have a good shot at the fair notice defense.
Mark, any comment before I follow up on you?
No, I think that's fair. I think there's a difference between what could happen on summary judgment and in front of a jury. And I had lost cases at the SEC that we were pretty confident we'd win just because, when you have 12 jurors sitting in a room, it can go any way. And I think there is some receptivity to emotional appeal. And being able to go out there and pitch, the SEC still hadn't quite figured out what to do with crypto at this point, would have some appeal to a jury. So I definitely see that.
Okay, now let me ask you, Jeremy brought up the point that a lot of XRP holders were thinking that maybe someone would have emailed and with these draft speeches, what about XRP? Or, and took that kind of, not necessarily fought for it, but just inquired about it. And to my knowledge, there is no discussion like that. But at the same time, there was a memo that was, and I know you're aware of it, it's June 13th, 2018, where enforcement lawyers like yourselves analyzed XRP and Ripple sales of XRP under the Howey test. The judge ruled that privileged. Now, but the judge, Netburn, Mark, she noted that there was no recommendation ever made at the conclusion of that memo that she read in camera. And you could correct me if I'm wrong or disagree with me. I've taken the position that by inference, that had the enforcement officer said, boy, XRP is clearly a security, there would have been at least tell Ripple to stop, like cease and desist letter, recommendation of enforcement, something. You wouldn't go another, basically 2.5 years before you bring an enforcement action. Is that a misperception of mine, or do you think there's some, rationale in that thought?
Yeah, it's hard to speculate. I wouldn't go as far as you go, partly because the investigation, to my knowledge, had not been done yet. I look at this, at the summary judgment papers, and the amount of data and information that's been developed by the SEC is pretty voluminous. And I can't imagine that was done in 2018. So there's a big difference between, in the abstract, based on what we know just from the public record, maybe it's a security, maybe it's not. That's very different from 2 years later coming and saying, here's the volume of tokens they sold, here's what the market looked like, here are the representations they've been making, everything that they based on the SEC's summary judgment motion. That was not developed in 2018. To my, I assume it was not. So it doesn't surprise me that at that time, they didn't have the information to say, we need to go and get a TRO tomorrow. That certainly wasn't present. And then, of course, they didn't, I don't think in the building they had a set policy yet or a decision on where to go with this. I mean, you can see that in the emails that the subject matter was in flux. And I'm, again, not shocked that between 2018 and 2020, there was a lot more conversation within the SEC, a lot more voices heard, and they began to move in a more aggressive direction. And Ripple was sued as a result of those, developments in policy thought and the investigative record.
Let me ask you too, on Office of General Counsel, is that a higher ranking office than Director of Corporation Finance, or is it equal?
My understanding is they're equal. There's multiple divisions, and there's the Division of Enforcement, Division of Trading and Markets, Corporation Finance, General Counsel. So they're all divisions. The heads of those are all appointed by the chair of the SEC. So there's not a hierarchy among the divisions. They each have a very different role in various processes, including enforcement.
The reason I asked, Mark, is when the Office of General Counsel says, you know, we don't think you should put ETH in there. You shouldn't give a direct statement like that. And Hinman ignores it and gives it. To me, that seemed odd. So I want to ask you that, what's your thought on that? And then the second part is something that caught my attention. I don't know if it did you, but the Office of General Counsel didn't say, don't include ETH because of any other reason other than it will limit our ability to say otherwise in the future. And as someone, you know, that frustrates me. Like just give us some clarity. Why do you insist on having the option to, you know, if you say he's not a security, then we can't forever prosecute them. So what are your thoughts on those two things?
Yeah, on the latter point, I certainly appreciate that. And having been on the defense side, and I represented some crypto firms when I returned to private practice after leaving the SEC in 2013. So I'm sympathetic to the frustration. Why can't the SEC just say this is or isn't a security? I tend to go back to an understanding that partly what I just discussed with you a moment ago, that until there has been an enforcement investigation, there's not enough to go on. You know, the SEC can say in the abstract, based on what we know in the public sphere, this may or may not violate the law. But until there's an investigation, it's premature. The SEC shouldn't be making a prescription or giving people that sort of specific guidance because they don't have a complete record. And then more broadly, the SEC, the securities laws are by design very broad. They're designed to allow the SEC to be flexible to react to changes in the marketplace and practices. I know it's a little pedantic, and certainly you know this, but for those who are watching this and don't, the example I like to pull out is insider trading. And I think a lot of people are shocked to learn there is no law against insider trading. There is no statute that defines it or says that it's illegal. There is a broad anti-fraud statute that says you cannot use deception, essentially, or false statements in connection with securities. And it was the SEC that, you know, some 50 years ago looked at insider trading and said, this seems to be fraud. This seems to be a scheme. And they sued people for that. And the courts, all the way up to the Supreme Court, said, yes, that is a form of fraud. So, you know, that is the way that the securities laws were designed, that as new schemes, new products emerge, the enforcement division has to be able to say this does or doesn't violate the law. And the courts are the backstop to either say, we agree, or no, SEC, you've gone too far. So I understand why the SEC would say, let's not get too specific in a speech because we don't know how the facts will develop.
All right, Jeremy, I don't know if you saw, but the Stuart Alderati, General Counsel of Ripple, they tweeted out a video, and Stuart had called for an investigation and into why this speech was given. And I'm going to ask you both this. Now, I would say to Stuart Alderati, welcome to the party, because I've been calling for an investigation, and Crypto Law actually ran a video and a campaign, and we had a Connect to Congress campaign that delivered almost 100,000 messages to all members of the House and Senate, just wanting an inquiry as to why this speech was given. So I just want to ask each of you, first with you, Jeremy, do you think, at least with these emails, it buttresses that request and that we should have at least an IG investigation?
I do, and let's be clear and blunt about what Ripple's really saying, because I think they're nibbling around the edges of it because they want to be, you know, they don't want to come out and accuse anyone of anything, but we can speculate. So my speculation is that what Ripple's position here is that William Hinman was somehow paid, and he was paid by the Ethereum Foundation or someone related to Ethereum to give this speech, give Ethereum a free pass. And then at the same time, and I think this is what really gets Stuart and Mr. Garland House's kind of gander, is that at the same time, he then at the end of the speech lays out these criteria, which, as his video mentions, have no basis in the Hinman test. The first one is decentralization, and the second one is how many of the tokens do the promoters still hold, neither of which have any foundation in the law, but which he's kind of made up to apply to digital assets. And if you really think about it, at the time, especially back in 2018, The one thing about Ripple was it wasn't decentralized. It was a banker's token. And you can imagine that that prong that he just kind of made up out of thin air from their point of view is an attack on XRP, because at the time Ripple had a lot of control over the validators, and I don't understand it exactly, but it wasn't as decentralized as Bitcoin, for example. And then the other, of course, big one is he comes up with this kind of test or something to look at how many of the tokens do the promoters still hold. Has no basis in the law, but it's definitely something that you can say focused on Ripple, because Ripple, of course, held like half of the tokens XRP ever produced. So, I mean, to cut to the chase, what they're saying is that this speech, one, was an Ethereum free pass, but was also an attack, a hit piece on XRP, which at the time was Ether's big competition.
And the only thing I add before I asked Mark the same question to what you said, Jeremy, is that Hinman now works at A16Z, which is the people that helped write that Perkins Coie memo. He's a general partner there. So in addition to his law firm being a member of the Enterprise Ethereum Alliance as an ongoing sharing profit, the people that helped write the speech, that ended up in the speech, some of their direct language, he's a partner with them today. And so I throw that out there for consideration as well. But Mark, I'm close to the case. It's why I wanted someone like you on the show. What are your thoughts? I'm not asking you to accuse anyone of anything, but do you think it warrants an investigation? And do you think there are people at the SEC who believe in it as an institution who would support it?
Yeah, I know it's unsatisfying. I'm always very cautious to go there. I mean, my job at the SEC was to look at the evidence and not speculate. And then on the defense side, we would make that case. And it could very well be that some of my former partners who these days are representing Coinbase and Binance and others, and I could very well have been doing that had I decided not to retire when I did, could make these arguments. So I leave that for others to do. I think the point that I would make, just to close the loop on this, is I do think it's important for people to realize that whatever one division director's motivations may or may not have been, that the way an SEC enforcement action is brought is independent of that. The Ripple case was brought because the Division of Enforcement conducted an investigation, recommended to the commission that they take a vote on authorizing them. At least three of the 5 commissioners voted to do so. The Division of Corporation Finance would have a say in that, would be able to come in, and if they didn't agree with the case, could potentially veto it or make it more difficult for enforcement. But it's enforcement and the commission going forward. So I do try to separate, what may or may not have motivated this speech and particular positions that Corporation Finance took from this lawsuit.
Well, let me share one more thought that you might not be aware of. I know Jeremy is. That goes to sort of the motivations that Jeremy was talking about. Bill Hinman's last day at the SEC was December 4th. And there was a rumored settlement talks were going on. Brad Garlinghouse and others have talked about it. Bill Hinman came back after he left, even though he had already left, and got involved in a meeting. And there ended up being no settlement. Now, I wasn't there. I can't speculate what was said. I just know it's a matter of record that he left and came back and got involved when, even after he had left the SEC. And so when you add all these up, it just starts, at some point you see so much smoke that you got to believe there's a fire there. That's all. And so, but I appreciate, your thoughts on it. Now, there was a lot more documents that were unsealed other than the Hinman emails that are honestly more important. And I know a lot of people might be surprised by that, but the Hinman emails are not, as both of you said, it doesn't go to the underlying issue, which was, did Ripple sell XRP that constituted an unregistered offering or sell? And that's really what it comes down to. And so we know all the evidence that Ripple's targeting the SEC and the Hinman and the conflicts and that. But I want to turn to the SEC's case, underlying substantive case against Ripple, because one thing that Jeremy and I both shared when people would always ask us, John, Jeremy, is the SEC going to win? Is Ripple going to win? And I publicly said that this overarching theory that XRP is a security despite the seller or the circumstance surrounding the sale, I believe the judge will reject that theory. Whether or not she finds specific evidence counter statements, we didn't get to see the exhibits. And I want to share a few thoughts to the audience because we've learned some of that. And before I talk about the case against Ripple and the SEC's chances, I think it's important to point out that we're living in an age of Celsius and FTX, Sam Bankman fraud, Luna, UST, fraud cases that have happened. Ripple was investigated for 2.5 years prior to this enforcement action. And after a 2.5-year investigation, they were not charged with fraud. They were not charged with misrepresentation, omission, or any of that. As a former federal prosecutor, I went on record to say, if I could had a good faith basis to bring a charge case in addition to an underlying Section 5 case, I would have. Just as a matter of course. And so I don't know how many crypto companies today or in years past could survive 2.5 years and not one single count of fraud be alleged. So I throw that out there, but that doesn't mean Ripple didn't do some stuff, right? That doesn't mean that there isn't a potential valid claim for a securities violation. So what I want to do is I believe this is the heart of the SEC's case. And that is that where they claim Ripple engaged in domestic efforts to foster U.S. investor appetite for XRP, including offering incentives and paying exchanges to list XRP, saying here's $1 million to, I believe, Kraken. Here's $5 million to Coinbase as incentive to list this token. Their website. So I'm just going to real quickly go through a few pieces of evidence because I want both of you to weigh in on its strength or its weaknesses. Let's first pull up 583. Now this is just an email where an investor reaches out to Ripple saying, talking about acquiring XRP in a large amount. And this is presumably an accredited investor who has a fund, hedge fund. And Ripple responds and tells them how they can. Let's go to 584. We're going to do this quickly. Another email, right, about over the counter and what's the easiest way to buy XRP. These are emails Ripple's getting back in 2016 or 7 or even earlier. Here's another one where one Ripple employee says to another Ripple employee, what do I do when I get these calls? And it says, I would direct them to how to buy XRP page that's on our website. Let's go to the next one. Here are basically chats between Ripple employees talking about, the difficulty in New York for New Yorkers to acquire XRP. And they're discussing it. The next one is where someone is basically over-the-counter market maker and Ripple's answering questions. So these are emails coming in and Ripple responding to people that have inquired to them how to obtain XRP. Let's go to the next exhibit. There it is on Ripple's website, how to buy XRP. You got Kraken and Bitstamp or this one. And Ripple shows you where you can buy it. This is like in 2016 or 17 prior to the Coinbase listing, right? And that this is evidence that the SEC is pounding to the judge. Let's go to the next one. Ripple gives reports. Ripple's a private company. They don't have to do this, but they give a report and there's where they say, here's our goals. And you see the goals there, which is just general goals you'd hear. These are our target audience. Ripple's letting the world know. Banking, blockchain industry, things of that nature. Then we got another exhibit. And Jesse Hines, an attorney, commented that today, timely, that he thought that this was transparency needed. Ripple's a private company. They don't have to do this. But Ripple went ahead and started producing their XRP market reports every quarter. Look at that. They're letting you know 3 billion XRP was released out of the cryptographic escrow. $2 billion returned to the escrow. They're letting you know where the XRP is going and being sold. Now, of course, Ripple's saying, look how transparent we are. And I say, no good deed goes unpunished, right? Because all of that is evidence now that the SEC is saying, look, Ripple, you're out there promoting it. And there are deposition testimony. I want people to know this, of Brad Garlinghouse, Miguel Valles, where they're talking about how Ripple needs to establish liquidity for their ODL project, right? If you're going to use ODL, on-demand liquidity, you've got to have liquidity in the market. So Ripple is taking steps to make sure that happens. So you need to get XRP on Coinbase. You need to get XRP on multiple exchanges around the world so that they can access that on-demand liquidity, make their cross-border transactions using XRP as a bridge of different fiat currencies in 3 to 5 seconds. And so the only way to do that is to make efforts to drive the ecosystem and liquidity. And so Ripple did offer incentives. I know others have as well, but that was what's going on in the market. And so so basically Ripple offered a rebate to Coinbase. We'll give you a minimum amount. We'll guarantee a minimum amount of trading volume. We'll give you a discount at the, things of that nature to basically drive that liquidity. And so Ripple, they cite Ripple. Ripple had tweeted out a petition to. They saw a petition that was out there for XRP holders wanted Coinbase to list XRP. Ripple retweeted it. That's evidence in the case, right? That they're being used against them. There was an internal employees discussed the online petition to get XRP. XRP Army is mentioned internally. There was a message by one Ripple employee that says, boy, it's really great to have an army out there that says things that we probably shouldn't say as a company, right? All of that is evidence. And I'll give my thoughts on it. But basically, I want to first go to Jeremy because, and then I'm going to go to Marc. Is this strong evidence, or is this just, a business doing their thing? What are your thoughts on it? Because I think I just described the heart of the SEC's case. Sorry, Jeremy, go ahead.
Yeah, no problem. First off, from what I reviewed, no smoking guns for the SEC either. So I didn't see anything in there. I didn't see a press release from SEC from Ripple to the general public saying, hey, we're going to do this and this and that, and that's going to make the price of XRP go to the moon. I didn't see that. And legally, I think, you're looking at the third and fourth prong, which is reasonable expectation of profits based upon the efforts of the promoter, right? So I think, so these things go to that, but legally, I think they have to be advertised or distributed to the public in general. And I don't know how much of the stuff was available or how much the public had knowledge. For example, it looks bad that they paid Coinbase $5 million to list XRP, but did the general investing public have knowledge of that or not? I don't know. I don't think so. But that being said, I look at these things kind of like how a young lady looks at a young man who's trying to date her. What is the woman looking toward? The woman's looking at little things that add up to a red flag where she's going to say, no, go away. I'm not going to date you. So all of these things might be small in and of themselves. It's just one email to one private investor. Okay, not that big a deal. That's not going to, win the third and fourth prong for you. But the judge is looking at these kind of like how a woman will look at a guy who doesn't pick up his mom's phone call or doesn't pull the chair out for her or doesn't open her door, to be old-fashioned about it. And when those things reach a certain level, she goes, you know what? I don't like this guy. He's just throwing me bad vibes. And that's the way I look at how judges will look at these cases is there going to be enough little small things that bug her to where it gets to a point where she's going to rule against us? And the bottom line is, and I think people need to understand this, is there is enough information out there for the judge to make a reasoned decision for Ripple, but there's also enough information out there for her to make a decision for the SEC. And really what she's going to do is she's going to give it the smell test. Is this a young man that she thinks she wants to be with for the rest of her life? Or is she going to move on and go to the next guy that's courting her? And so I think that you have a lot of small little things that the SEC has piled together. And, that'll just be up for the judge to take a look at that guy and see if she likes him or not.
Mark, before I turn to you, I've seen SEC enforcement lawyers and heard them read the Ripple complaint that the SEC filed and said it's a slam dunk and it's a great case. When I read it, I saw a lot of noise, like they use non-fraud language fraud-like language in a non-fraud complaint. And it just had a lot of what I consider noise in it. And I never viewed it as that great of a complaint. I thought it was overbroad that, XRP holders are all in a common enterprise with each other around the world and Ripple. The theory that the entire XRP ecosystem, that we're in a common enterprise with exchanges and each other and Ripple. But, you are an enforcement lawyer, right? I think you said 16 years. You had 100 people under you. What's your honest take when you see this evidence? Because I believe a lot of people focus on the sales, but I want to remind the audience that an unregistered offering is enough. It doesn't have to actually be a sell. A, am I right? And two, what's your thoughts?
Yeah, no, I agree with what you've been saying. It's not a fraud complaint. They didn't charge fraud, but there's a lot of inflammatory language in there. Plus, you throw in the fact that they sued 2 individuals, which is not typically done with registration, strictly registration cases. I'm speculating. I think the SEC saw this as, I don't want to say egregious, but more than just an issuer that screwed up. There was something that upset the staff. They saw this as a little more than just, an error that was made. And they wanted to signal that both through the individual claims and the language they used. But still, it is a registration case. And as you say, just an offer of securities is enough. There's no intent required. And, if I were looking at this, if this had come across my desk when I was a defense counsel, I could defend this case. But I think I'd be advising my client that, the odds are they lose. I think the SEC has the better argument. It's a civil case, preponderance of the evidence, 51% wins. And I think they have that. I think partly for the reason Jeremy is saying, there is so much out there that maybe each piece isn't enough. But I tend to look back. It's interesting to me to look at Twitter and the discussions of Howey, and people what does this prong mean, and get into the weeds, and forget the initial part of Howey, which is what's the purpose of the Howey test, and what is the economic substance? What is really happening here? And I think it's really hard to deny that when Ripple is raising $1.5 billion, that's the SEC allegation, from public investors, yes, some people out there are buying it for on-demand liquidity, and that increases over time. And it may be why a secondary market trade is a very different animal. But the amount of money that's being raised, I don't know that it's in good faith to say this is just people buying it because they want XRP to transact business. These are people buying it and being marketed to because this is something they can buy and profit from as any other investment. They could have bought Ripple stock, but instead they buy XRP. Functionally, it's the same thing. That's the perception that is being created here. And, it's not an equity interest. I understand that, and that causes legal complications. But I think on balance, what's really happening here is something is being sold to people for speculative purposes. And that sounds a lot like a security. And I think if you set aside the bad optics, the SEC's issues in developing its policy, the fair notice defense, and the individuals just get to, did Ripple offer security to the public? I think they've got the SEC has a stronger argument there.
All right. Before I turn to Jeremy, I would do want to say, because I call it like it, when someone asks me, and it sort of goes to Jeremy's, red flag, where little things. Someone asked me, John, what's the worst case or the evidence against Ripple? It would be what you talked about, because when you compare software sales to XRP sales, you're going to see like 40 million versus 1 billion, right? Like This is how much money they make in revenue for their software to banks or financial institutions. This is how much money they've generated from XRP sales. I would push back on the speculative thing. It's a pet peeve of mine, Mark. When you read the Howey case, the Howey court says right after the test that whether or not the nature of the instrument is speculative in nature, it's immaterial. And it also says whether the underlying asset has intrinsic value is irrelevant. And those are two big factors that SEC folks and Gary Gensler focus on. They focus on speculation and the tokens don't have intrinsic value. The Howey court said those are immaterial and irrelevant. But Jeremy, I know you're a bit on time. What are your thoughts? What are your thoughts on what Mark said?
Well, I mean, I don't disagree with Mark, and I haven't ever said that there's a 0% chance the Ripple loses. I think that in my opinion at the end hasn't changed since the last video I did, which I really think that there has to be a contract in order for there to be an investment contract. I think that's the right result, and I really think that the fact that that Ripple had no obligation to these purchases of XRP after it was out in the world, to me it's dispositive, and I think that would be the right result. I know that's probably most attorneys I've spoken to don't think that's the result that will happen at the trial court level, but it'll probably be something that maybe an appellate judge would look at, if anything. But I really think that's problematic for the SEC if the judge can get her mind right. In fact, I'll just in those emails, one of the attorneys that was making comments kind of made that comment that, hey, look, even in the Howey test, what happened was some people bought the land, but they didn't also get the contract for the management of the land. And that was not, that's what the comment says in the Hinman emails, that was not the sale of a security. And I think that is what we have here. We have people buying the land and not buying the contract. Now, I guess the SEC's argument would be, well, you could have an implied contract, and that's what really the third and fourth prong of the Howey test is. But I don't think any reasonable person looks at an email or the fact that they try to get it listed and say, well, you had an obligation to do that for me. You were responsible, because if you sued Ripple and tried to say that, you'd be thrown out of court and maybe sanctioned. So I think that's the proper resolution, in my opinion. Of course, I'm not the judge, so here I am and just waiting to see like everybody else.
We're going to wrap up in a minute, guys. But Mark, let me ask you, I think the SEC has a problem with the common enterprise. And I'll tell you why. First of all, when you look at the SEC's published digital asset framework that's on their website, you go to footnote 10, the SEC literally says, we don't view common enterprise as a distinct element of the Howey case. They literally say we're going to ignore the Supreme Court in so many words. But the theory that the SEC had was that Ripple was the common enterprise. But then Ripple got them through requests to admit that there's no legal interest in Ripple. There's no post-sale duty obligation, that Ripple owes XRP holders absolutely nothing. Then they got their expert, I can't say his name, I could, but I'm not going to say the expert's name, who opined that the common enterprise was the entire XRP ecosystem. Coinbase, John Deaton, Ripple, Jeremy Hogan, who are all in a common enterprise with each other, vendors, market makers, just crazy overbroad theory. Well, XRP holders got involved as well, and that expert wasn't relied on, and his opinion on what a reasonable XRP purchaser would rely on was excluded by the judge. And so they lost that. And then finally, in their summary judgment papers, they said that XRP itself represents the investment contract and the common enterprise. And so when I look at applying the law to this case, I struggle with agreeing with you that the SEC has the better argument. And I look for where are specific transactions. Forget, whether it's a transaction scheme or a contract, what is the specific? And the only ones you get is individual emails that the public doesn't know about, the promotion to Coinbase offering incentives that the public doesn't know about. So do you think that it's enough for Ripple offering Coinbase a incentive or payment to list XRP, that specific transaction violates the law? Is that what we're looking at? Or and what are your thoughts on my common enterprise comment? And then we'll end with Jeremy.
Yeah, and I take it back to what Jeremy was saying that, looking at any piece of this in isolation doesn't seem sufficient. I think really you do have to look at the broader picture. It's not so much the fact that there is payment to have this listed on an exchange. I think if you look at that in context, that doesn't sound like something you do if you are selling oranges, if you're selling product, and maybe it is. Maybe you want to develop use for the product you're selling. But I think in the eyes of the SEC and looking at everything else that they submit in their motion, it does seem like they are trying to create value for this token to sell it to other token holders. Not so that, it's one thing to say we're going to create relationships with banks so you can use XRP for liquidity. It seems more like we're trying to create an ability for you to take your token, wait for it to go up in value, and then sell it to another somebody else interested in a token. And that sounds like a security. That seems to be the economic substance. But I grant you that there is complexity here. I think some people from the SEC aren't confronting this. And I think that's one of the biggest things I took away from some of the emails that came out is recognizing this gap, this regulatory gap. And I think they do need to be fair. There is a regulatory gap because a crypto token, at least the handful I'll acknowledge are legitimate. I'm a skeptic. I think a lot aren't. But those that are legitimate, there is this sort of hybrid nature. You can buy it as an investment because you think you can save it and then use it to finance your children's college fund. Or you can buy it because it offers you online liquidity or some functionality of the underlying blockchain. And that's different. That is a new phenomenon. And I think that's where the law is unsettled. And I think that's why you see the SEC throwing out language that pivots from brief to brief because they're not really sure what's going to fly. They are throwing a lot of things at the wall to see what sticks.
Jeremy, I'm going to ask you your final thoughts and if you can make a prediction, because everybody's on their XRP holders want to know what's this mean? What's this mean? No one can wait, and then I'd ask Mark to give us his prediction if he's willing. Go ahead, Jeremy.
Sure. So my initial instinct when I knew this question was coming was to say, I think that the judge is going to split the baby at some level and say sells from, maybe when the ODL came into existence on or not sells. Then I kind of thought, no, that's maybe a little bit of an easy way. I'm gonna go maybe bold, although it's easy. We're just like talking on the internet, but say that I think Judge Torres is kind of brave enough to say, you know what, there's not a lot of case authority out there on it, but I'm gonna say there has to be a contract to have an investment contract, and I'm gonna go with a 39.967% certainty on that.
Mark, when you say the SEC has a stronger case, does that mean SEC motion for summary granted, $1.3 billion, disgorged, or does that mean she parses it out, splits the baby sort of rationale that Jeremy's talking about?
Yeah, I think there's a difference between what I think is the stronger case legally and what I think is going to happen. I think that if you had taken out some of the optics, some of the things we had talked about previously in terms of fair notice and so forth, I think just strictly on the law of Section 5, I think the better answer is for a court to rule as a matter of law that the offering violated Section 5. That's what the case is about. I don't think the individuals, I don't think the SEC is successful as to the individuals, but I think as to Ripple, I think as a matter of law, the SEC wins. What do I think is really going to happen? I'm more where Jeremy is. I'd actually go beyond that. I think the SEC loses this case on summary judgment. I think the easier thing for this judge to do is put it all in front of a jury or mostly in front of a jury. I think the interim decision she made just on unsealing this part of the record wouldn't have been necessary if she wasn't planning to put at least some of this in front of a jury. And I suspect that's probably where this goes. And I don't know that the SEC, I don't think the SEC is likely to win this case in front of a jury, either because of the optics or because of its complexity. The SEC on a case like this does not have a great track record in front of a jury.
Yeah, no, that's great. I would point out too, and this could just be boilerplate that the judge used, but when when she unsealed the documents, she did say, quote, whether or not I rule the Hinman emails are admissible, implying that's for another day. Now, obviously, she'd only be ruling on the admissibility if there was a jury. And I've always said that people underestimated the chances of a jury, whether it's to the common enterprise prong that I talked about, whether it is to the reasonable expectation of profit. I mean, it's hard to be in a common enterprise or rely on the efforts of a company that you are oblivious exist. You know, I can tell you when many XRP holders, they just bought XRP because it was the third largest crypto and it was cheaper than Bitcoin. I mean, let's just be honest. That's a fact. My daughter was one of them who just said, you know, I'm buying a Bitcoin and splitting $5,000 and buying half of ETH and XRP because I hear my dad talk about this new asset class. She'd never heard of, you know, even Vitalik Buterin or Satoshi Nakamoto, and let alone Brad Garlinghouse or Ripple. And so I agree with you. I think that there's a really strong likelihood that we see. I think the SEC gets denied their motion for summary judgment as written for sure. I'm, you know, very confident in saying that. But that doesn't mean I'm confident that Ripple is going to win. I could see their summary judgment being denied, and she leaves at least one or two triable issues out there, because I don't see enough specific transaction evidence that's in there, that unless you're just going to go with the offering, like Ripple offered this token in general as a Section 5 violation. And so regardless, any final thoughts from either one of you? We'll end there.
I was just going to say the problem I have with a trial on the Section 5 violation is if you're going to, you know, force the judge to say, these are what, hey, jury, these are the issues. Here's a verdict form. Here's are the issues you need to decide. What is in there in that verdict form? I just can't imagine on a Section 5 violation what the judge would be asking the jury to rule on.
So your point, Jeremy, to be clear for people listening, is that she says that during this period of time, Ripple violated Section 5, but the fair notice issue goes to the jury. Is that what you're saying?
Yeah, that's how I think it's more. I think it's more likely she would rule on the Section 5 violation. And what I'm pointing out is the reason I think that is she has to rule on it, because what disputed issue of fact is there for a jury to make a decision on as far as the Section 5 violation? I mean, everyone's admitting, you know, the press releases that Ripple sent out, they're not denying that they sent those out. It's just what's the legal implication. And so when I think jury trial, I'm thinking, what's the legal fact that a jury is going to have to make a decision on? And I can't think of one. And that's why I think she's got to rule on it. Although that being said, I had a case last year, which was a straight issue of legal fact, and the judge just punted on it and sent it to the jury. We literally had attorneys in there arguing points of law to a jury. It was ridiculous. We had an expert attorney who was being crossed by the defense attorney, and it just doesn't go well. But I could see how she could do that. I just don't know what the jury would be asking to make a decision on.
Mark, any final thoughts before we sign off?
I'm reading the news as eagerly as all of you, and I have the benefit of seeing both sides of it. So for me, it's win-win. If the SEC wins, I think that's ultimately better for investors. If they lose, I think it might be a better use of the SEC resources to say, maybe this isn't out of space we should be in. Let's go focus on something else.
All right. And if you sign off right now and were to play some music, what are you going to play?
I've been staring at my Sgt. Pepper over my head for the last hour, so I think I'm going for some Beatles.
Nice. All right. Well,
there you go.
Gentlemen, thank you so much. I appreciate you taking the time. Look forward to seeing you and hearing on you on Twitter. All right.
Thanks, Jeremy.
Thanks, Mark. Thanks, John.
For everyone out there, I know the show was longer than normal, but hopefully you enjoyed it. Everyone have a great night. See you next week.